for conversation today for residential, because as I was saying earlier in the morning, it's mid-month, so it's one of those days that landlords wanatafuta sana tenants. Mlelewana ukumelipa by, let's say, the 10th, alafu saa it's the 18th of the month, you haven't yet paid your rent. What are your rights and responsibilities, first of all, as a tenant? Even for a landlord in a residential place, what are your rights and responsibilities? We'll be discussing that, and we'll be glad to hear your voice. First off, talk to us on our SMS number 22047. Send in all your questions, because we're going to have a lawyer, an advocate right here to help us digest your conversation. You can also call us live. We'll be opening our phone numbers 0795 045 864. When you call us, tell us your name, where you're calling us from, have your TV or wherever you're watching us from mute or have it off. It's going to have a very seamless conversation. And then tuonge 0793-267-279 is our WhatsApp number. We'll be filling all that. But then let me introduce the advocate this morning. Maina Patrick Njama, karibu sana.
Asante sana.
Looking dapper.
Thank you, sir.
First off, I always like starting with a brief intro of who you are.
Yes.
And a brief on what is the first thing that people need to know when it comes to even the legal tips on the rights and responsibilities of both tenant and a landlord.
Okay, thank you for hosting me. My name is Patrick Njama Maina. I'm an advocate of the High Court of Kenya. I practice primarily in Ruiru, but we also have an office in Kitengela and Nyeri and Mokoroini. When it comes to rental matters, especially residential houses, there's something that both parties need to primarily understand. It's a legal and lawful relationship, and it always works best if you are on good terms, you understand your duties and obligations, and you perform them to the best of your ability. And where there is a challenge, communication is key, so that you avoid escalating issues.
Right.
Yes.
So what are the kind of the legal instruments and laws that, let's say, govern when you go into court? Hypothetically, mimi nisumbuane na landlord ama caretaker or vice versa. Where is the first place that you go to, first of all? And let's say when you go to court, what kind of laws are they looking at here?
Primarily, the rental issues, the first port of call should be the Rent Restriction Tribunal, these being residential buildings. However, there's a challenge. When the Rent Restriction Act was enacted, it was supposed to protect those tenants in low-cost housing in Nairobi primarily, because it was the major urban center by then. The limit of rent within whose jurisdiction the tribunal administers was set at 2,500 shillings. You can bear me witness that it's really hard to get a house, even a single room, going at 2,500 shillings at the moment. However, unless the rent has been assessed and ascertained by the tribunal, any matter can be filed in the Rent Restriction Tribunal. But before issues escalate that much, you are allowed by the law to write notices, or if you are the tenant, you write a letter to your landlord expressing your dissatisfaction and the complaint and giving them time to address that issue. Then, should they fail to address the issue, then you are allowed to escalate it further. Yes.
Right. Remember, a question of the day for you is, do you understand your rights and responsibilities? Do you understand your rights as a tenant or a landlord? We'll be happy to listen in to you. We've posted that question on our Facebook page, so you can head there and talk to us. The couple of comments that I am seeing so far, and even other questions regarding this, because say, do you understand your rights as a tenant or a landlord? You can call us live 0795 045 864. Also, text us on WhatsApp 0793-267-279, and 22047 is our SMS number. So Kamau Ngugi, what if the assets owned is less than the owed? What about tenants who remove his or her belongings before leaving? These are just some of the questions that are coming in so far. So even before we really get into some of those questions that I know they will be piling up as we continue, even for the callers,
Yes.
Help us understand the difference between residential as well as commercial, in the sense that right now you'd find, let's say, a four-story building.
Yes.
Is primarily it was built to be residential.
Yes.
But on the ground floor,
Yes.
unaingia unapata ni, let's say, supermarket or some stalls, and then the first floor is residential now.
Okay.
So it's as if the whole building is between a residential and commercial. So in case now there are certain problems when it comes to rent, res, and all that, how is this solved?
What you're going into are what we call matters of user, which are ideally regulated by county government. When you are putting up a structure, you apply for approvals, and the first one that is done is a change of user. If you want to do there are three primary options. One, it can be an outright commercial building, where it's strictly business, no residences allowed. Secondly, it can be strictly residential, where like mansionettes or even an apartment that's strictly residential, no businesses allowed. Then there's the model that's mixed user, where you have the lower floors ideally because of the public traffic. You can't regulate with businesses, they are open to the public and you can't regulate who comes in and goes. But with residential buildings, there should be restriction and regulation of the incomings and ingoings. So in mixed use buildings, you find ideally the lower floors are reserved for business, while the upper ones are reserved for the residents. So what happens is, if someone on the business end has a legal issue, and they are under the jurisdiction of the business premises tribunal, they'll take their complaint there.
Okay.
If someone is in the residential side and they have a complaint, then they approach the rent restriction tribunal.
Right. So I want to go with the hypothetical of someone, the caretaker comes and knocks to this person,
Yes.
to this tenant, and says, ni date 18,
Yes.
haujalipa rent.
Yes.
Anza kusema wewe kwanza hapo unapiga kelele and all that. Amwambie wewe kesho nikirudi umehama.
Yes.
Hapa. So does this person now then go to the tribunal, because you told us that the rent restrictions tribunal
Yes.
is provided for?
Yes.
So does this tenant now go to this tribunal, and if so,
Yes.
what kind of papers, what exactly are they going to do there?
Okay. Ideally, any notice to a tenant or even any communication from a tenant to a landlord should be in writing. Most of the times our people prefer doing things, as we say, kienyeji, without following the laid down processes and procedures. However, if a tenant finds themselves in such a situation where they are being kicked out unceremoniously, so to say, they can apply the rent restriction tribunal for with a legal process called a certificate of urgency. And they explain the urgency to court that I'm being kicked out unceremoniously, I need your protection. And what I need is interim protection before our issues can be determined, because by the time you are getting to being kicked out, either you haven't paid rent or the other complaints. Before those complaints are determined, I want you to give me an interim protection so that I'm allowed to continue occupying this household space until this matter is heard and determined. Yes.
Right.
And the court now gives an order which is served on the landlord or the caretaker, and they are not allowed to interfere with the tenancy until their issues now are ventilated in court. Yes.
I think that as well answers someone who's asking, does a caretaker have a right to frequently bother a tenant? One remunerated me from drinking and asked me to prefer women. I moved out. So in this case, does this now tenant then now go to this tribunal? And also because, I mean, he puts the option of he moved out. alifika mahali akasema mimi nimechoka na kusubuana na caretaker, let me move out. But then in the light of this, someone is watching and they realize, hey, by the way, last year kuna caretaker alikuwa ananisumbua and this wasn't right. Can you then go to the rent restrictions tribunal or some of this to the court really and sue this caretaker?
If you are to sue, you can't sue your caretaker from last year, unless it's on issues of reimbursement of any deposits. And then you need to understand also, tenants need to know that although they have rights, they also have responsibilities. For example, that person has mentioned drinking. As long as you're drinking within your house and you're not acting as a nuisance to the rest of the occupiers and other fellow tenants, the caretaker does not have any right to come and bargain and interfere with your quiet possession and enjoyment. However, if your quiet possession and enjoyment turns out to be a nuisance for other tenants, then the landlord or the agents or caretaker have a right to come and, one, they can evict you. The first thing they should is to give you a warning that you are being a nuisance through ABCD. You should rectify that, or limit your activities to your house. Even playing loud music, it's not, that person mentioned women, it's not the caretaker's responsibility to keep track of how many people you are bringing in your place, as long as you're not being a nuisance to the other users.
And typically when you walk into some of these residential places, some of them have some laid out rules. Hata kwa gate, ukiingia, and they say, hapo usiingie past 10 p.m. Hakuna mtu atakufungulia gate, plus so many other rules. And it would seem that a number of residential places wako na their own constitution. Maybe ukiingia unatumia unaambiwa this is our constitution, that these are the kind of rules that you're going to have specifically designed for that place. Does the law recognize some of this? If the landlord, for example, would go to this tribunal and say, no, sisi tuko na hii constitution, sisi kwa hii nini yetu, tuli agree that you should not come after 10 p.m. And you as a tenant, you also signed it. Does the law recognize some of these constitutions that are drafted by residential places?
Those rules and regulations are only apply to the extent they are in agreement and accordance to, one, our statutes, and secondly, the Constitution. The Constitution being the supreme law of the land. On limiting people's time of entry, once you have leased out a house to a tenant, you can't limit their ingoings and outcoming. What if someone works on a night shift and they are released from work at 4 a.m.? What if it's a doctor who is out on a night call, or other professionals in the medical field, security sector? Sometimes we are also called upon to go and assist our clients who have been arrested late at night. So you can't set rules limiting the enjoyment of these rental premises. My access to the house, as long as your rent is paid and we don't have any outstanding issues, my access to that house as a tenant should be unhindered. You're not supposed to interfere with it. It's another matter to regulate the incomings and outgoings of visitors and non-residents, because at the end of the day, a landlord also has a responsibility to maintain security in the premises. So there should be some regulations to limit the ingoings and outgoings of non-residents and visitors, but they can't tell you that you won't have a visitor past certain hours. They can insist that as a tenant, you need to come and take your visitor at the gate, so that we know exactly where that person is visiting. But they can't say that we won't allow people in after a certain time. So
what if let's say the owners of this residential place, or even estates, because this even transcends to certain estates. You'd find, for example, if it's a Muthaiga Residents Association, for example, Tengele Residents Association, they form even their own constitution, because now it's not only even the buildings themselves. Yes. Be even no littering around. They have some of these laws. Yes. So the question would be, this residential, even associations, going to court and seeking a stamp of approval. Can that be allowed? And just so that the court can say, well, we've taken a look at this makes sense.
You know, at the end of when you're making rules and regulations, especially as an association, you make rules to govern and take care of your mutual interests. However, if someone feels that these rules and regulations are infringing upon the enjoyment of their rights, then they have a right to go and challenge the rules and regulations set, and then the court will decide whether the same are reasonable and applicable or not.
The reason I'm asking that is because you'd find in certain residential estates, for example, they have one of these common rules: do not, let's say, take photographs. And this might be, let's say, some kind of high-end estates, yes, where even the population isn't too much. Yes. So they'd have one of those. No photo shoots around here, no, let's say, public service vehicles getting into these places. Yeah. Can someone go to court and say, this is infringing also on my right? I'd also want to take photographs here, for example.
With photography, if it's a private estate, you don't have a right to go infringing on other people's privacy. Yeah. But if you are a tenant there, then you can take photos within your area where you have occupancy and possession. On issues of them limiting public access, public service vehicles from accessing estates, there are estate roads that are primarily private, and they are there for allowing the residents to access the main public service, public access roads. So you can't force public service vehicles to be accessing the private estates roads, as long as they have access to the public access roads that serve that estate. Yes.
All right. Let's continue looking at some of the comments that we're getting so far. Felix says, heri kutoa roof, kesi baadaye, kwani tenant is overprotected than landlord. And this goes to show that we normally favor, and you can also tell us, does now the court really favor the rights of the tenants and forget about the landlords? What rights does the landlord enjoy?
One, the most primary one is the right to get payment. They have invested and they should get paid for their space. The second...
and for that one, so who is supposed to, let's say, put the exact date? Because in some residential places, they'd have, let's say, specific timeline. Let's say by the 4th, for example, by others would say by the 10th. What is that particular timeline? But then, as you point on that, yes, I'm actually have a caller right now. First caller, jina ni nani, unatupigia simu ukiwa wapi, and karibu sana to our morning show. Hello, habari asubuhi. Jina ni nani?
Naitwa Kevin.
Kevin, asante sana kwa kutupigia. Unatupigia ukiwa wapi?
Nikiwa Nairobi.
Nairobi hapa tu. Uko na swali for wakili ama feedback? Wakili anakusikia, you can direct the question directly to him.
Niko na shida na niko na swali. Kevin.
Yes, endelea, and tafadhali mute your TV ndio usijisikize. Hello Kevin, kabla unanipata, I hope umemute TV kabla uendelee.
Yeah.
Yes, continue the question. All right, tafadhali mute your TV, just have it off. Otherwise, hatutakuwa na very seamless conversation. That is Kevin from Nairobi. You can also call us live as we discuss the rights that tenants have, as well as even landlords. And our question for you is, Do you understand your rights? And do you understand your rights as a landlord, also as a tenant on that? Tupigie simu, tuambie unatupigia simu ukiwa wapi, your name, and wakili will be answering your question. So back to what I was asking earlier.
Okay, there's something that people need to understand. When you are making a contract, the contract is always between two parties.
Okay.
In this case, there's a landlord and a tenant. And even if they have a standard format where they have said that rent is payable by this date, at the beginning of the tenancy, you have a right to inform the landlord. For example, they might say that we want rent paid by 5th, but you get paid around 10th. So you tell the landlord before the commencement of the tenancy that on the part of the payment date for my rent, I would want it to be after 10th because my rent becomes, my salary is payable on 10th.
Is that done by word of mouth, or do you have to sit down and...
Ideally, you should have it in writing.
Okay.
Unfortunately, sometimes you find people have a dispute and they never had this in written form. It was just orally agreed upon. But to avoid having issues in future, it's always ideal to reduce it in writing so that you both understand your obligations and the applicable penalties if you default.
Right now, courts also allow writing in form of, let's say, WhatsApp messages. Yeah. So if I have this conversation with my caretaker, kumwambia niaje, manze mimi rent yangu siwezi kulipa by 10th, maybe by 12th because inaingia this time. Then you had a whole conversation there. Can I print out that conversation and bring it to the courts? Or does it have to be a whole contract written and drafted by a lawyer, took sign, nini hadi kakona stamp?
There are two situations. First, if it's at the point of commencing the tenancy, it should be captured in the contract.
Right.
However, sometimes life throws curveballs and your finances are a bit shaky. In such a situation, you should inform the landlord in good time, in writing, that I'll delay this time and I'll pay by this and this date.
Right.
Yes. And if the communication is on WhatsApp, it's admissible as evidence if that issue escalates.
Right.
Or any other written form, also email, SMSs. Yes.
And we're still on that bit of landlords, the rights, also the responsibilities as well. And I want to bring in another piece of legislation, the Rent Restriction Act, which I can see restricts rent increases by the landlords. Tell us about that, because you'd find it's January. I know for my one-bedroom house, I'm paying, let's say, 12,000 shillings. Imefika March, landlord ameona, wa, na hii economy itabidi niambie watu niongezee 2,200 each tenant. Alafu aditumie message niambie ongeza 2,000. How is that supposed to be done, that process, according to the law?
Actually, that's the reason why I'd said we should have written contracts for all tenancies. But sometimes it does not happen. Because a contract, if you are taking up possession of a house, let's say for 2 years, we have to adjust the rent to the realities of the day. There's inflation, there's rising costs of living. A written contract most of the time provides for a percentage by which rent will be increased. And in common practice, it's after every 2 years, there's an increase of 10 or 20%. So that it's something that you should have certainty. It's not arbitrarily that someone just wakes up because there's kuna kashida kametokea pahali amepata pressure ya pesa and then they decides ataanguka na tenants niwa watamsort. No, it should be something that's certain, that I know if I took possession, let's say in May, and rent is reviewable after 2 years, I know in 2 years' time, in June of, we are in 2024, in June of 2026, rent will be increased by this amount. Yes.
So first off, so that means again, there needs to be, if the landlord wants to increase the rents, what timeline should be given? And I'll for 3 months notice on BA. So today is January, or rather today is actually July. So by October, rent itaanza kuongezeka. So anzeni kujipanga this coming months. Also, does this mean now the landlord has the absolute power to have that increase? Because I mentioned 2K. Kuna wengine anaweza angalia one, wacha niongeze 10K. Inaweza kwa even double your rent. Does the court give the landlord absolute power on the amount of rent to be increased?
No, let's not even go to the court first, because it's the law.
The law, okay.
The law is they are allowed to adjust rents
okay.
to fit the current realities. But the adjustment should not be arbitrary. It should be based on something. Ideally, a contract that gives certainty so that the parties know what's expected of them. But where there's none, then that's where it's left to the interpretation by the court. The reasonableness of time depends on the duration of the tenancy. There are people who, especially with residential areas, they keep the rent, the term of the contract at a yearly basis. It's renewable at the end of the year, then you agree again on new terms or something. But even then, they can't double the rent. It has to be a percentage that is justifiable and reasonable. Yes. And if you disagree with the figure they have stated, you have a right to challenge it in court so that the court assesses the reasonableness of that decision. Yes.
To something else that I know a number of callers will also be asking,
yes.
The landlord may also decide to, let's say, cut other services. You haven't yet met, you haven't, let's say, paid fully the rent amount, ama umelipa partially. And the caretaker decides, hata sikusubui, hiyo maji unatumia naenda nakata. Kama ni steamer box, pale meter box, nakata, for example. And even other services that the tenant enjoys, for example. What does the law say on this? The kind of services that this tenant enjoys?
It's an unfortunate trend, and in Kenya, most landlords tend to disconnect amenities to punish tenants. And it raises an issue once, because that person will still pay rent in full, or whatever time they pay. What happens to the suffering and the time they went with it? It's supposed to be a tool of putting pressure on a party to pay, but unfortunately it's not lawful. There are legal mechanisms for recovery of rent, primarily distress for rent, where if a person has not paid rent, all tenancies should have a security deposit for that purpose. In case someone defaults, you are not starting in the middle of the month and you say you are not holding anything. So if they go up to, you had given an example of 18th, without paying rent, you can issue them with a notice that your rent has been due and payable and it's in arrears now. Because you shouldn't sit on the deposit during the term of your tenancy. It's supposed to be there as a security in case you default. But now if your default goes beyond your security deposit, then the landlord has a right to invoke distress for rent, where they'll give you a notice. If you fail to rectify the breach of contract and pay up, then an auctioneer will come and distress your goods.
Right.
And even the auctioneer has a process they proclaim, give you 7 days. If you have not paid within 7 days, they'll come and take your goods and give you a period of 14 days within which to redeem them. If you don't redeem them, then they can be sold so that rent is recovered.
Right. It's like you read my mind. I also wanted to get into now auctioneers largely, but I know we'll get to that broadly. So many questions on that. We have a caller, Josephat kutoka Eldoret. Habari asubuhi, Josephat. Hello Josephat, watu wa Eldoret mnaendeleaje?
Tuko wazima kabisa, labda nini?
Sisi tuko salama. Uko na swali au maoni?
Ya, niko na swali.
Yes.
Nilikuwa naishi kwa nyumba ya 9K.
Ulikuwa na?
Nilikuwa naishi kwa nyumba ya 9K.
Okay.
And then before one man nitoke, nikainform landlord nataka nitoke. Nirudishie hiyo deposit. Akaniambia ana kwa sahi, lakini unaweza toka as the time course, nitakurudishia hizo pesa. this now 2 months. Hajarudisha hiyo pesa. Sasa nimeshindwa nitafanyaje?
Sawa. Asante Josephat. I hope wakili umepata the question? Yes. Sawa. Wakili will be answering your question sahito. Josephat there from Eldoret. 0795045864. We're discussing, do you know your rights as a tenant, as a landlord? We definitely mtu alikatalia na deposit yake for that one. Josephat, how can you help Josephat?
Actually, the funny thing is that most people don't know that you can go to claim a refund for a period of up to 2 years through the rent restriction tribunal. However, the challenge that we have, especially those of us who practice in courts, is this. Most of the exits from tenancies are not properly documented, because ideally by the time when you are exiting a house, ideally the landlord or their representative should come with a checklist. They go through the house, note whatever is broken, needs to be replaced, and then give you a breakdown of costs of the repairs, repainting, and then whatever is over and above is supposed to be reimbursed to you. The deposit is not supposed to be reimbursed at the point of exit unless you are footing those costs out of pocket, where you say that, okay, we have assessed any damage and repairs, I'm paying, give me back my deposit. That is supposed to be a quid pro quo. But if they are going to do a set-off, they do the repairs and painting.
Even as you continue, sorry to cut it short, yes. I've realized we can use some of these legal terms. Upoteze mtu akopale mashambani anashangaa quid pro quo ni nini? So yeah, unaweza tumia
lugha ya mtaani
ndio elewa.
Quid pro quo is a give and take, where you say I'm paying this, but you also owe me this. So let me pay for the repairs and painting and give me back my deposit in full. Because there are also deposits for amenities. If there's no pending water bill, there's no pending electric bill, you should give back that person their deposit in full.
Right.
However, if all those things have not been ascertained, you should exit, and part of it should, the exit document should even include water bill, any outstanding electricity, garbage costs, all those should be deducted first before you are reimbursed.
Right. Let's hear from Kamau in Naivasha. Kamau, habari asubuhi.
Salama sana.
Welcome to TV47. Do you have a question or feedback on our conversation?
Question?
Yes, please.
Nilikuwa nauliza.
Credit ya Kamau ni kama imefanya ile kitu. Kamau, you can again reload, utupigie simu tena. Ni kama it was a very, very burning issue. Usiogope, calling us wherever you are. Tell someone to also call 0795-045-864 is the number. So we were answering what Josephat was asking about matters deposits. Ni kama someone on Facebook also agrees. Anasema Amos Kabiro, landlords wengi ni wakora kwanza hapa Nairobi. Wanapenda kuitisha deposit sana lakini hawarudishangi. Yes, that is according to this person. Earlier on, you're telling me that you can't sue your former caretaker. Ule caretaker wa last year, for example. Is that correct?
No, I said you have a window of 2 years to claim any refunds. What I said you can't sue them for ni kusema alinifukuza juu we had issues. If it's not related to a refund, you no longer reside there, so you have no rights as a tenant. But if it's related to a refund, that's a legal issue that arose during the tenancy period.
Right. So does this deposit, because I'm pretty sure wengi watauliza, even for the 2 years, does it accrue benefits, interest rather?
Unfortunately, no, because most of the times when we sue, you are only awarded costs and interest from the date of the judgment. Yes.
Wacha tuchukue simu ya Evans from Kenyatta Road. Wanaitanga K Road. I think that is in Thika Road. Evans, welcome to TV47. Habari asubuhi. Do you have a question or feedback?
Kwa wakili?
Yes.
Kwanza habari asubuhi wakili.
Njema sana Evans.
Maze mimi ningependa ubonge Kiswahili kidogo. Unajua unabonga hizo terms za learned friends, wengine wetu ni educated friends. Sasa hizo terms hatuzielewi vizuri.
Sawa, nitaongea Kiswahili.
Sawa, ubonge Kiswahili kwa wingi so that wale wengine wenye hatujaelewa hizo terms tuzielewe. So niko na swali. Unapata kwamba kuna nyumba zingine za kuishi ambazo ziko na agents. Na hizi nyumba ziko na agents, alafu ukiingia pale unapewa contract nyingine imechorwa na mawakili na terms zingine ziko nzito hazieleweki, mtu unasign tu juu unataka kuingia kwa nyumba. Wakati ule ambapo sasa umeambiwa kama deadline tarehe 10, kwa mfano hiyo tarehe 10 imefika kama ni ka Friday, weekend ndio hiyo, so kado inaingia kama ni Tuesday. Imepita na like 3-4 days. Basi unashtukia agent ndio hao huko kwa nyumba, umetoka, wamebomoa nyumba, ukirudi wamechukua vitu wameenda nazo. So hiyo sheria inatokana na wapi na ni kwa nini wanabomoa wanaingia kwa nyumba? Wanakuja wakisema tuko na contract na tuko na maybe ulisign contract kwamba utalipa tarehe fulani, umepitisha siku 3 na wamebomoa nyumba wamechukua vitu zako. Je, hiyo ni halali?
Sawa, asante sana Evans, salimia sana watu wa K Road. Mshinde salama.
Nashukuru sana. Wakili ubonge Kiswahili tafadhali.
Sawa.
Amesikia. Asante sana Evans. 0795045864 is the number to call us live. But before you even get more callers, sadia sana Evans hapa hivi.
Evans, ningekwambia hivi, hiyo hatua ya agents kuja kuvunja nyumba yako si halali. Wakati wowote umekosa kulipa kodi ama rent kwa muda unaofaa, kuna notice zinafaa kupeanwa na either kama ni agents real estate management companies ama ni landlord mwenyewe. Anafaa kukuambia ulikuwa unafaa kulipa rent hii siku, haujalipa, umepitisha na hizi siku, tafadhali rekebisha. Na akupee muda wa kurekebisha kama siku 7. Siku zenye ulikuwa ukiingia kama tenant pahali unapeana deposit. Kama deposit yako haijaisha, hawafai kuanza njia yoyote ya kurecover pesa kutoka kwako. Wanafaa kwanza kungojea hii period ya deposit yako iishe. Kama umetoa ya mwezi moja, wakati mwezi unaisha, sasa landlord hakuna kitu chako ameshikilia kama security. Kwa hivyo huo wakati anafaa kutumia sasa kwanza ile process nimesema ya distress. Distress basically ni kujia vitu zako aziuze ili ajilipe kodi ambayo haujalipa kwa huo muda.
Right. We do have all the way in Kisii, Samson. Habari asubuhi, I hope uko salama. Welcome to TV47. Do you have a question ama ni maoni?
Niko na swali hapo, question
Yes.
Yeah, assuming I've been staying with my landlord for the last 4 years.
Okay.
And I want to exit. Is there a timeline that I'm supposed to maybe do it in written, maybe 3 months early, or I can just say I'm leaving tomorrow, according to the law?
Okay. So yeah. Ile notice ya kama unataka kutoka?
Yes.
Okay, sawa. Wacha wakili atakuwa nakupatia jibu sahihi. Thank you, Samson.
Okay, thank you sir.
Lazima ni ambie caretaker manze, the next 2 months been a lefty place, ama yeye tu ashtukie kesho asubuhi anaona movers and lorry movers hapo nje, mimi natoa vitu.
Kawaida inafaa kuwa kwenye kadarasi contract yenye mmeandikiana, notice period ni gani. Mara nyingi Kenya watu wanahitaji notice ya mwezi moja nitatoka nyumba. Ukitoka kabla huo mwezi uishe, ama unaweza kuwa hata mwezi umeanza, umelipa rent lakini umepigwa transfer kazini, unafaa kwenda mtaa mwingine. Ukiamua kutoka, utatoka bila notice, lakini hautarudishiwa rent ya hiyo mwezi yenye ulikuwa ushalipa. Si haujapeana notice umetoka tu. Ukitoka tu hiyo mwezi ambayo umetoka hauwezi rudishiwa, lakini mwezi ukiisha deposit yako unafaa kurudishiwa.
So sheria inapeana one month notice.
Nimesema imeachwa kwa contract. Like, inafaa kuwa agreed upon between the parties. Lakini kama haiko in practice inakuanga mwezi mmoja.
1 month, okay. So.
Ile period, okay, wacha niseme hivi, ile period ya duration unalipa rent. Kawaida residential houses ni kila mwezi. Juu nyumba commercial kuna pahali unapata wanalipa quarterly after every 3 months. Ama by annually ile after every 6 months. So depending on your duration yenye unalipa, hiyo ndio inafaa kuwa notice period yako kisheria.
Right. Ben Ngetich Jr. on Facebook says, my name is Bernard Ngetich, I reside in Uthiru, Nairobi City County. My landlord and caretaker is threatening me to lock my house and throw my items away. This is because I have delayed paying July 2024 rent. I have a patient in hospital. That's why I have delayed. He didn't give me landlord-tenant agreement. What can I do? But even as you ponder on that, I'll be rereading it again. Ambio tuko na a caller from Dandora. Habari asubuhi.
Salama sana.
Yes, majina ni nani?
Naitwa Simon Kiongozi kutoka Dandora.
Asante sana kwa kutupigia and karibu sana to TV47. Swali au maoni?
Ni swali kwa wakili.
Yes.
Wakili, nataka kuuliza, kukiwa kuna tenant ambaye tuko naye na hajalipa muda wa miezi 6. Na akiulizwa, akipelekwa kwa akakataa kuitika samo. Na amekataa kulipa nyumba. What are we supposed to do?
Right. Tenant amekataa kulipa 6 months. What are you supposed to do?
Yes.
Sawa. Asante sana wakili, will be answering a question right about now.
Sawa, Simon, unafaa kumpea notice ya useme zile arrears ako nazo na upe muda alipe, umwambie unataka alipe na siku 7. Asipolipa, you distress for rent. Unatuma auctioneers wakuje wafanye valuation ya vitu yake, alafu wiki moja ikiisha wanazichukua wanaenda kuziuza.
So kama
na kama hizo vitu hazitoshi pesa yenye unamdai, uko na haki ya kumfuata kotini ikiwa deni akulipe.
So for example, umetuma auctioneers wakuje this week. Huyu tenant alienda kasafiri Mombasa, hayuko, and there's no one else in that house. Is a caretaker and these auctioneers, are they allowed to break into this house and waangalie as much as alishapatiwa hiyo notice?
Kuna mambo mawili. Wakati auctioneer amekuja, amedistress, ameproclaim, ameangalia zile vitu kwa nyumba, ameandika, amekupatia, umesign, amekupea siku 7. In case ufunge upotee, ako na right ya kubreak in. Kawaida wanaenda kotini, wanaomba order ya kuja kuvunja ili waingie kwa nyumba wa access.
Okay. Right.
Lakini kama mtu hayuko, hata awe haufai kuvunja tu bila. Ukiona mtu hayuko, ameenda, hakuna communication, enda kotini uombe. Useme nina huyu tenant hajakuwa kwa huu muda, there's no communication na yeye kabisa, na naomba breaking orders, ili kukuwe na an independent party, in this case wa supervise, mwenye ataandika vile mmepata nyumba ikiwa na zile vitu mmetoa.
Sawa. Wacha tusikie Joseph kutoka Kericho kabla simu katike. Joseph, habari asubuhi, watu wa Kericho mnaendeleaje? Hello Joseph.
Hello, nakupata, nakusikia.
Yes, karibu sana. Do you have a question ama ni maoni?
Ni swali.
Yes, please.
Niko na swali kwa wakili. Ningependa kuuliza hivi. Katika sheria za Kenya kuna sheria ambayo inatuguide kuhusu mambo vile jinsi ya kulipa nyumba, ama niseme bei ya nyumba. Useme for example nyumba ya mabati, unaishi kwa nyumba ya mabati, unapata mtu anaweka shilingi karibu 6,000 na ni nyumba mbaya, hata mtu anaweza kulala ndani. Alafu unapata nyumba zingine ziko hata ndogo ndogo sana, ameweka bei juu sana. Sasa tujui kama sheria za nyumba zinasema nini kuhusu vitu kama hizo. Hapo unaweza kusaidia kama hiyo katika sheria za Kenya, ile rate ilifaa tulipe kwa nyumba hizo za mabati ama hizo ndogo ndogo, ama kuna size ya nyumba inafaa mtu akae. Hiyo ndio swali langu.
So, asante sana Joseph, salimia sana watu wa Kericho.
Asante.
Wakili?
Actually, maneno ya rent, if you contest one of the functions ya rent restriction tribunal ni assessment ya rent yenye inafaa kulipo. Natuma a licensed government valuer, anakuja anaangalia taking into account vitu kama amenities zenye ziko hospitali, shule, access ya barabara, maji, stima, vitu kama hizo, and then wana issue an assessment. However, serikali ya Kenya ama sheria haidictates ile rent inafaa kulipwa. It's left to the parties. Na si lazima uishi nyumba ya mtu. Ukisikia hiyo rent anakulipisha na nyumba ni mbaya, hutaki kulipa, unafaa kutafuta pahali ambapo ukae pahali pa kadiri yako. Hauwezi kuwa unaenda ukipigana na wenye nyumba ukiwaambia hii rent yako iko juu sana, inafaa kushukishwa. However, kwa hizo nyumba za bei ya chini zenye hii Rent Restriction Act ilitengenezewa, ilikuwa inatengenezwa to protect watu from arbitrary increases ama exploitation yenye mtu anatake advantage, kama zile carton shanties za nini. Mtu landlord ametengeneza nyumba za carton na analipisha watu pesa mingi kwa sababu hawana uwezo. So
okay, and because I see you have about 3 minutes to wrap it up. Before we get that, just a follow up here, unatuambia what he's talking about, and he raises ile mtu amejenga nyumba ya mabati, and then the prices are not really commensurate to what kind of amenities zinafaa zikuwe hapo. Rightfully, yeah, as you say, if you pay, you can go elsewhere and seek another residential place. But then, where does the tribunal come in? Does it come after the fact that someone who was a tenant here alienda kwa hii tribunal akasema hapana, hizi bei ni there too much? Or should it be the other way around, that when someone is setting up a residential place, doesn't have to be the unshit kind of houses, could even be nyumba ya gorofa, two story, 3 story, before one's at a kuliz, the tribunal assesses some of these houses and says this is the cap. As much as yes, you're saying it is left to the party, but then just to avoid all that, why is it after the fact? Does it, because it now sounds as if they are knee-jerk reactions that the tribunal has?
No, it's not a knee-jerk reaction. It has a mandate to carry that out, but it's not mandatory. It may carry out assessment.
Okay. Oh, okay.
But if it was shall carry out assessment of all rents, then the government would have a regulatory body that sets rents for various zones and various types of houses. Lakini sasa kwa sababu hakuna hilo jukumu, rent imeachwa ni mnasikizana mwenye nyumba na mwenye anakodi. Kama msiposikizana, hapo ndipo sasa ikikuwa mna mvutano, mnaenda kwa tribunal, inafanya assessment ione kama unalipisha kodi yenye inafaa. Lakini mwisho ujue nyumba mali ya mtu amekupa, umelipia ili utumie. Hata mkianza kuvutana haitakuwa yako. So if you have issues with your landlord, yes, you enforce your rights so that the process is followed. But most of these relationships work best kama mna majadiliano na masikizano. Mkikosana muwe na mnavurugana kila wakati, hata wewe ukiwa mwenye nyumba hauwezi taka kuwa unahisi kwamba unakandamizwa. Kwa hivyo sheria pande zote mbili ni kama msumeno inakata mbele na nyuma. Kwa hivyo kwa upande mmoja ina protect tenants na pia landlords wako na rights zao ambazo pia sheria inazi-enforce.
Right. Before I get your last thoughts, there's someone who was asking about bodies. Yes, Roda, hi Wakili. Is there any body in Kenya which deals with the rights of tenants really? So even as you answer that, can give us your parting shots and wrap it up with contacts where, because I'm pretty sure so many people have even more questions right now where they can direct those questions. But before that, kuna body yenye ina protect tenants and now also landlords, a specific kind of a body,
the landlord
organization.
I believe the landlords have their association. And for tenants, one of the bodies that they can direct their queries to is one, the Law Society of Kenya, of course, the Consumer Protection Board. Yes, I believe they would be well guided with that. Sent their enquiries there.
Right.
As for, you said contacts.
Yes, your parting shot advice, someone listening to this, just a takeaway home, and then your contacts.
Okay, my parting shot is this. In any legal relationship, it's best if each party understands exactly what they are getting into, what their rights are, duties, and obligations. For landlords, you have provided, umepeana nyumba yako watu waishi. The first right you have ni kulipwa, na pia uko na right ya kukikuwa na shida kwa hiyo nyumba, uko na right ya kufanya repairs ya nyumba. Na wewe tenant uko na jukumu la kulipa mwenye nyumba. Pia uko na jukumu ya kumaintain nyumba, si kuiharibu kila kitu. Na ya tatu uko na jukumu la kuishi vizuri na wale watu ambao wale tenants wengine. You should not be a nuisance to other tenants. And if that relationship becomes strained, try resolving it amicably. Msikizane, mkishindwa, sheria imepatiana mechanisms kama rent restriction tribunal zenye mnaweza jadili hayo, mnaweza suluhisha hizo shida zenu.
So contract that someone can reach you?
I can be reached via 2 numbers, 0710 326 680 and 0739 356 950. I'm also available on Facebook as Patrick Njama Maina.
Okay, all right.
At Twitter at St. Patrick's and at Maina Kemumu Advocate.
Asante sana.
Yes.
Thank you very much, Maina Patrick Njama, Advocate of the High Court, for helping us on this conversation on matters, the legal tips that you need to know as a tenant as well as a landlord. This conversation continues on our digital platforms, so follow us right there. For matters legal tips, we take you all the way to the gym for Fitness Thursday. We'll make sure that tumeanza weekend